So thank you very much for inviting me. The report before this one was about digitalization and AI, and you can see why AI does not work because you can see that behind me it's supposed to be the United Nations screen, and I'm supposed to be kind of the whole of me, but half of my hair is gone. So I think that this is a very clear indication that maybe AI does not work exactly the way we want it to work so far. The report that I submitted was on conservation and cultural rights, and I thought it was very important to discuss this because the several stakeholders had told us that it is very important. Several stakeholders had said that there is a lot of discussion about environmental law and the right to a clean environment, and this is fantastic. But they didn't know, and there is a beginning of a discussion about more wider human rights when it comes to conservation. Unfortunately, based on the fact that there have been a lot of violations, and there still are a lot of violations of human rights, but there have not been a lot of discussions about human rights and cultural rights in specific. So that's what we tried to do in this report. Also, several discussions that we had to do with the way we define and we use cultural rights. So, cultural rights traditionally have been seen as focusing on cultural heritage and on artistic freedom, but they have not really focused so much on the priorities and the wishes and the visions that people have about the life they live. So, when we talk about cultures and cultural frameworks, we talk about our identity. So, this is much wider than just merely the heritage and merely the artistic freedom. So we talk about our ways of life, which includes the way we develop the link, the relationship we have with our environment, and the way we develop this relationship. It means our philosophies, our practices, our traditions, but also our inspirations, our visions for the future, our priorities. So if this is what cultures are, then the right to these cultures means that we have the right to maintain and develop our traditions and our cultural frameworks and our practices and patterns, but even more so, maybe, we have the right to be in the decision-making bodies that will start materializing our future, that will start working on how our future is going to be. So Farida Shahid, the first UN Special Rapporteur in the field of cultural rights and human rights, said that cultural rights are the right to connect our past to our present and the visions we have for our future. So in this respect, conservation cannot be taken away from our wishes to develop and to influence the relationship that we, but also our societies, are going to have with the environment and with nature. And the second reason why, so hence, it's not only about the right to life, so not to kill, unfortunately, the some of the local populations, so that you can maintain the so-called peace in the national park. And it is not just about the right to relocate or not relocate and compensation, but it is also about our vision, cultural rights in specific, our visions and our traditions and our priorities. And I think that people who work on environmental law and on environmental practices have started realizing this, and that's why they wanted some guidance on what are the state's obligations. And the second reason why I wanted to do this report was because of the existing challenges. So we see that at the moment there are a lot of places where the idea of conservation is set to mean the model of conservation is the model of making the park, making the area of beauty, the area that the state wants to conserve, completely free of any other organizations and certainly of any people there. So this is the treating these areas of beauty as a castle and trying to push everyone outside. And I think that this starts from the wrong point, because biodiversity cannot be seen without cultural diversity. Nature is not an enemy and is not separate from human beings, and human beings cannot be separate from nature. We are all together. So this idea, this model of fortress conservation continues to exist a lot, and really still is the main model that states and transnational corporations advocate for. And this is why and also, unfortunately, many conservation and environmental organizations also advocate for this model. So in this respect, it is quite sad that we see that there is this huge gap between what cultural rights actually say, what human rights say, and what is happening on the ground. And this was very important. And this was also our first challenge and our first purpose. So our first purpose is to remind the states and the conservation actors and the transnational corporations that when we talk about conservation, we mean about conserving, preserving the environment that includes the animals, the human beings, the areas, and the diversity that exists. So first of all, cultural diversity cannot be seen separate from biodiversity, and this was also our first challenge. And it is very interesting that when I gave the dialogue with the states, more than 60 states wanted to talk, and they all agreed with me. So they all agreed that, really, when we talk about biodiversity, we also talk about cultural diversity. And then some of them went on to tell us how they have excluded the local populations from this area in order to preserve it. Some of us went on to tell us how they support other organizations such as UNESCO or the World Bank in actually pushing out the people. And some of us said to us how closely they work with organizations that we know materialize, support the fortress, the model of fortress conservation. So the first challenge and the first important element is to acknowledge that fortress conservation has failed, and that there is a link that cannot be broken between diversity and biodiversity. The second challenge was to interpret the laws, the practices, the guidance, etc., in line with this, in line with cultural rights. The reality is that environmental lawyers and environmental organizations and stakeholders traditionally do not see cultural rights as part of the guidance they give. And this is where I ask for your help. I think that by the end of today, even before I started talking, we agree on this idea that cultural diversity has to go together with biodiversity. Yet, When we go to guidance, when we go guidance documents, toolkit that various organizations create on and the environment, interpreting the existing legal documents, somehow cultural rights are forgotten, and we don't interpret the texts in a way that reinforces the message and really applies cultural rights. So nature conservation agendas have to include cultural rights. So and finally, most importantly, we have to talk and agree on what we say the cultural rights approach is. And a lot of states, what I said to you earlier, would smile. I mean, good states that wanted to do, to do what they're supposed to do. They would smile, and they would kind of agree with us, but they seem not to exactly understand what is the cultural rights approach. And the cultural rights approach is that derives, of course, from the binding, legally binding document that 183, I think, or 185 states have signed and ratified, which is Article 15 of the International Covenant on Economic, Social, and Cultural Rights, as interpreted by the General Comment 21 of the Committee on Economic, Social, and Cultural Rights, and also by the various reports of the consecutive special rapporteurs. For example, in the past, there are a lot of very important reports about what are cultural rights. We also have a report on development and cultural rights and what we mean about development and cultural rights. So all these are the legal basis, if you want, of the state's obligations. And this is also another challenge, that states seem to believe that this is good practice, and it's not good practice. This is the minimum obligations that states have because they themselves have agreed to have these obligations. So the first issue is to the cultural rights approach. In the cultural rights approach is to ensure that there is no discrimination, non-discrimination. And when we talk about non-discrimination, there's non-discrimination in the way that the state chooses which areas to be preserved. There's no discrimination in how you treat the people in these areas. There's no discrimination on the redress that you give to people in these areas. There's no discrimination in the voices that you listen to and you hear. So I have heard a lot about prejudice and discrimination in state conservation policies. I have heard a lot about specific groups that are considered as backwards or primitive, and where these groups are deprived of their resources and dignity. When I was last week, 2 weeks ago in Geneva, I heard yet again from states saying to me that the reason why they have pushed people out of where they have been living for decades, for hundreds of years, is in order to protect them so that the lions don't eat them. As if the people who have been living next to the lions for centuries do not know, that they should not be eaten by the lions, and the so-called expert who has been in that area twice or three times, knows exactly how to protect the population. So first of all, non-discrimination. And non-discrimination has to be direct non-discrimination. So these people have to go, but also indirect discrimination. But unfortunately, more importantly, is structural discrimination. So we see that, specific sections of the populations are seen in an inferior way. And these are the people that have become throughout the decades voiceless. And these are the people that they themselves now sometimes don't have the tools and don't have the know-how, to come back and gain their voice in public spheres. And of course, we also have to keep in mind the intersectional discrimination, which is we have to pay particular attention to women who are also in the local populations, people with disabilities who also are in the parties that are affected by conservation. It is very interesting that I'm talking to people in France because, one of the major issue that your state and my state, Greece, have is that they do not accept, in at least at international law debate, they don't accept positive discrimination. However, international law is very clear on this. And France and Greece can go on saying again and again and again how we're all the same and the state treats everyone the same, but they don't because we don't start from a neutral space. So, the fact that I am in Greece and I am Greek, very obviously, and I speak the language, and of course, I am educated and I have the know-how, makes me, as you can understand, puts me in an extreme citizenship, or the son of the Albanian migrant who has gained the Greek citizenship, although that's pretty difficult as well, and is a farmer in a plot in kind of in the middle of Greece, and works with the land. I, who have been brought up in Athens and don't even recognize the different plants, unfortunately have more of a say than the guy who was brought up with nature and who knows exactly how nature reacts to various initiatives. So, but then again, they are in a much more vulnerable position than I am. So international law recognizes very clearly in a legally binding obligation, which is the International Convention on the elimination of all forms of racial discrimination, that positive measures may be taken when people are found in a more vulnerable position. And make no mistake, the committee that interprets the convention, the Committee on the Elimination of All Forms of Racial Discrimination, has said that this is not at the discretion of the state, when especially responding to France and the US. They said that when these conditions apply, when we have vulnerability and discrimination because of that, then taking positive measures is an obligation of the state, not at the discretion of the state. And this is minimum standards. So first of all, the cultural rights approach ensures that, there is no discrimination. Secondly, including, advocates for positive measures for specific people of the population. Secondly, a cultural rights approach underlines the need for redress in cases where violations occur. Unfortunately, we have seen that cultural rights in many places, especially in Western states, are non-justiciable. So you cannot really go to court with a claim specifically focused on cultural rights. You can go the right to life, you can go, planning permissions, etc., but not, very often not cultural rights. So this has to change. And also, and most importantly, maybe for my mandate and for the 6 years that I will have been in this role, it is about participation. So it is about the cultural rights approach is that we expect that everyone who is affected by conservation will have a voice. We expect that minorities will have effective participation, so not just participation. So this means that the state has to take measures to ensure that their participation is effective. And we expect that indigenous peoples and local populations will have free, prior, and informed consent, which means that if the indigenous group or the local population says that they do not want this area to get a UNESCO award because this would mean that they will have to leave the area, the state has to stop. So for indigenous peoples and local populations, they have veto. For minorities, they have an added protection. And again, we see that this does not happen because even when we have asked transnational corporations that are involved in conservation or environmental organizations, when we have asked them, in your decision-making forum, how many minorities do you have? At best, they will have said to us 2 out of 20. The rest are academics, policymakers, and government officials. I'm sorry, but if you have 20 people and you have 2 members of minorities, first of all, how did you choose these 2? But secondly, even if they scream, are they going to be heard? At the end of the day, the president of the committee is going to say, let's vote, and that's the end of it. So I think it is very important when we talk about implementation, when we talk about participation, to talk about real participation, meaningful participation, and effective participation. Related to this, if I may say, is this discussion about sciences. So we had various states and NGOs, conservation organizations who have told us we're only doing what science says. Okay, which science? Science by whom? How do we understand science? And it's again the cultural rights approach. You know, in order to understand science, you have to ensure that you define science in an inclusive manner. So, you know, the person who has been working in the previous example that I gave you with the Greek farmer, you know, the Greek of Albanian descent farmer, the person who has been working, you know, with the land for 30 years, are we going to say to him that he has no scientific observation to share with us? Are we going to say that, you know, I would only have scientific scientific approach because of my 4 years learning about the views and opinions of usually quite entitled, usually men, usually with close links with governments? So I think that, you know, the sciences have to be interpreted in a way that includes experience, and the seeking of truth through experience. So of course we're not going to base our conclusions on prejudice or on myths, but from myths to actually, you know, listening to the observations that the people who are living with nature have, and not listening to them and saying that these observations are not important, is really not the cultural rights approach, but also it is against cultural rights. And also it is against our benefit as a society, because, you know, of course, we all want solutions. We all want the planet to survive and our lives to be enriched by our connection with nature. So conservation strategies must embrace and recognize a level of scientific pluralism that is necessary for addressing the biodiversity loss that we see. So diversity not only of conservation methods, but also diversity of knowledge. And this, you know, again, I have a lot of people, especially human rights people, that say, yes, they agree. But when I went to my official visit, I think it was to Laos, I asked the International Food Organization, about the slash and burn practice. And this is a practice that people in Laos have been advocating for, the local populations have been advocating for a long time. And they were completely dismissive. The reason why I asked them is because they included in one of their materials the fantastic initiative they have, that they have been working with the governments, not specifically Laos, with the governments to ensure that slash and burn is not practiced anymore. Now, I am no science in this respect, but I do know that a lot of local populations and a lot of indigenous peoples, you know, would advocate for this practice. And I think that we they deserve to be heard, and they deserve for this practice not to be uh, a priori dismissed, even if we agree that the time has come because the lands have the structure of the lands have changed because there's not as much land to allow for it to have the rebirth that slash and burn practices have, etc. But we need to discuss it. So this is in general the, very simple in a way, elements that we advocate for, and we advocate for how that we advocate on the importance of the cultural rights approach in any legal, regulatory, and policy framework governing nature and biodiversity protection at the domestic level. We have found a lot of resistance. So we have found smiles, and yes, we all agree at the first level. But when it comes underneath to that, we have found a lot of resistance. And resistance sometimes does not look like big tensions, but it looks like pushing the argument aside and ignoring it. So the silence of the states is a very well-known technique to if states do not want something to happen. And I'm afraid that big conservation organizations sometimes use this technique. And we have found that this limits the effect that the report has had. I think that the one of the biggest challenges that I feel, and if I can take 5 more minutes, one of the biggest challenges that I feel that I have encountered is not so much with the states, although yes, of course, very important, but it is with the transnational corporations, because as you know, the transnational corporations do not have legal obligations to protect and to respect cultural rights. These are very limited in domestic settings, at the domestic level, and even more so, and even more so, not when they go outside the state borders. So it is very difficult for me to discuss with transnational corporations about how they need to preserve the environment, but also to preserve cultural rights. And it is very difficult for me to understand, to break the chain that exists in these situations about the transnational corporation that is working with the government and have employed another a security company that has employed a local villager to go and push the indigenous people out, or to destroy the local spiritual elements of their culture. This chain is very difficult to follow. Areas of particular concern for me are the conservation-related evictions. That's why I spoke a lot on the conservation-related evictions, and on the tourism-related loss of meaning of cultures. There is this emphasis on tourism that is very destructive at the moment in several states. And I think I spoke about the donor and funder accountability, which is the bigger issue, and we're really waiting for your suggestions how we can approach this. So in concluding, I think this report came out of the need of stakeholders to clarify and to ensure that we know what we're talking about when we discuss conservation models. And my main message is that there can be no biodiversity if not cultural diversity, and this means that we have to everyone has to respect and to adopt a cultural rights-based approach, which would mean non-discrimination, including a wide understanding of culture, non-discrimination, which includes positive measures, and of course the right to participation as well as redress. And what I have said and I advocate for is that impact assessment studies that just talk about the loss of environment are very important, and we didn't have these a few years ago, but now it's time to go to the next phase and to have human rights impact assessment, and specifically cultural rights assessment in areas where culture is affected. I'm really looking forward to our discussion. Thank you.
Thank you very much. Est-ce qu'il y a des questions, du coup, que vous pouvez poser en anglais, évidemment, ou en français et qui seront retraduites? N'hésitez pas. Donc, ouais.
I am so sorry that I didn't make this discussion in French, but I would murder your language, and you would not like that.
Ok, no problem. Understand.
Merci beaucoup, c'était extrêmement intéressant. Il y a un sujet où ça m'a vraiment fait réagir. On a parlé justement de la question des droits, des respects culturels. Et je sais que nous, par exemple, il y a des combats qui sont menés en France contre des types de chasse particulièrement impactants pour la biodiversité, de ce qu'on appelle la chasse à la glu, où en fait on chasse de tout petits oiseaux avec de la colle et qui n'ont pas d'intérêt pour la nourriture, mais qui sont des chasses culturelles du sud de la France, ou par exemple la tauromachie, et qui a une vraie question de débat entre le respect des droits animaux et le respect du droit culturel humain, et où il n'y a pas vraiment de réponse satisfaisante. Comment, à l'échelle de l'ONU, vous réfléchissez à ces sujets-là? Merci beaucoup en tout cas.
Thank you very much. As you know, in the United Nations, the discussions are very broad, so I'm not aware of specific discussions in this issue, at least in the human rights, in the human rights bodies. However, what I would say is that it's a very interesting and very topical question. What we do focus on, you're absolutely right. We have focused on animal culling in specifically when it is part of livelihoods. So, for example, reindeer herding, salmon catching, etc. So, in a way, this is a bit easier in a way. When it is part of the cultural frameworks, but not as recreational, I think the important thing is, you see, that's the interesting thing, scientific knowledge, but scientific knowledge based on what the community itself would say, and of course also taking into account the expert's opinion and trying to have a discussion about this. So for me to say that hunting just as a recreational practice of animals that need, culling for various reasons, it would be fine. But kind of having this recreational activity in endangered species or in species that generally are suffer by the way that are being hunted, this is a discussion that has to be brought to the agenda more. I think that the problem with human rights, and if I may say so, France and Greece and other states I feel that they don't fully understand this, is that to do something about human rights, one needs to have two steps. The first step is to identify whether there is a violation or not. And the second step is to discuss what is the most effective way to deal with this violation. And sometimes law is not the most effective way. Discussion in the community endless discussions, kind of trying to understand each other's scientific evidence, try to move forward, to evolve the culture, are sometimes more important elements than a law that says, and we have seen this with respect to the wearing of the burqa in France, and the hijab, etc. We have seen that kind of similarly in Belgium, in Greece, etc. So I think that it's such an interesting question. Maybe the answers are not satisfactory because it's a gray area, and in an attempt we have to ensure that animals are preserved in the same way that cultures are preserved.
Oui, essayez de vous exprimer un peu fort pour que...
Il me semble que vous avez dit qu'il y avait 195 pays qui ont signé le texte. Est-ce que c'est la totalité des pays membres de l'ONU? Quelles obligations ont-ils de l'appliquer dans leurs lois nationales? Et y a-t-il des États non membres qui ont signé aussi ce texte?
So the UN has at the moment 193 states. I think it's 185 who have signed and ratified the International Covenant on Economic, Social, and Cultural Rights. If the state has decided to ratify a covenant, this means that the state has the legal obligation in international law to transpose it to its national system. If the state has only signed but not ratified, this means that the state in general says that I will respect it, but give me a bit of time to make sure that my legal system is okay. But if you have signed and ratified, this means that yes, you have the legal obligation. For the states that have not signed and ratified, so for the other, I don't know, 10 states or whatever, there is a core obligation, and you can kind of push the obligation from there. So you can say that, okay, the right not to assimilate people is customary international law. It doesn't matter whether you have signed something or you have not signed something. You cannot assimilate people. But conservation, by throwing them out and by pushing them. So, for example, in Laos, they are pushing people to stop being hunters, and to become engaged with the production of rice. Okay, whether you have signed or not the convention, this is assimilation. So, you're not supposed to do that as a state. But your next question, I'm afraid, would be, okay, and what happens if they do violate these rights? And what happens if they don't violate, if they do violate these rights, if states violate these rights, is that we try slowly to convince them to stop violating them. Human rights are in the crossroads between law and politics, whether we like it or not. And human rights are on the basis of state sovereignty. So we have, as an international community, we have agreed that that international law is going to be based at the state level. And there isn't a state that is going to act as police. And there isn't a group of states that are going to act as police. So that's why we are all getting frustrated with the failures of international law at the moment, because it couldn't be otherwise. Because no matter what I say, I would not like the US or the Russian Federation coming and telling Greece what they should do, or who's going to decide which state is a good state in human rights and which state is a bad state in human rights. So unfortunately, yes, these are legally binding instruments. Enforcement of these binding obligations will not look the same as the enforcement of the domestic law, which makes our life more interesting.
Ça voudrait dire qu'il faudrait réussir à traduire dans le droit national, finalement, les droits internationaux.
This means that the best way is to have international laws transposed in national laws, or to have some commitment of the government, of the state, through guidance or through protocols or something else, that white papers, etc., that the existing legal instruments, the existing laws at the national level are going to be interpreted in a way that respects, in this occasion, cultural rights. So this means that the best that I could hope for is that in the new constitution of the state, they add a element that says cultural rights are important and have to be protected. This is very difficult, so there will be a law that will say cultural rights, although it has happened, this is what now some states are trying to do. So otherwise, there would be a law on cultural rights. Otherwise, there will be a cultural rights plan of action, such as this is what exists at the moment in Spain. This is what Scotland are trying to put cultural rights in their new bill on human rights. Wales have now issued a paper where they say that cultural rights are important for the future generations. So different ways that states are trying to include cultural rights in their domestic levels, so that we can also use them when it comes to conservation and environmental protection. Or you can go to and we've done that. I mean, I've been asked to do that. You can go to the national court and you can say, this happened with me in the UK. As the UK has signed and ratified this convention, you, Mr. Judge, have to interpret the national law in line with this international convention that the UK has signed and ratified. Difficult.
Il y a une question de
Marie.
Marie.
Oui, merci. Euh, Toujours sur cette même question, mais si, en fait, si ça vient de l'intérieur du pays, vous disiez que, par exemple, au Royaume-Uni, on peut se rendre devant la Cour nationale pour demander à ce que le droit soit appliqué au niveau national. Est-ce que l'étape d'après, ça pourrait être justement de se rendre auprès de la Cour de justice internationale en tant que membre d'un pays, par exemple, membre d'une population qui a été discriminée au sein d'un pays, euh, en faisant valoir justement cette ratification, mais au niveau de la Cour de justice internationale?
So criminal court is going to be difficult, but if you go, especially for these cases, but there are a lot of other places where you can go. So for example, there is a committee on economic, social, and cultural rights that France and Greece and all the states have to present themselves to every 4 years and have to say what they have done to respect this committee. And then people of the committee have what we call shadow reports. So that, you pass them 2 pages that say, well, actually, they haven't done this and they haven't done that. And the committee member asks the states, why haven't you done that? And then this goes, hopefully, to the concluding observations. So because of the nature of international law, we don't have a lot of international courts as such. The ICJ is really when it comes mainly for very big violations. The International Criminal Court is, huge violations. But the United Nations have this monitoring. Or the thing that I would urge you to do is to write an email to the Special Rapporteur in the field of cultural rights and to say that, this is my organization, this is the violation, can you, France or Greece or Thailand does not respect the cultural rights in conservation. And then I take this and the fantastic Jean make it into a communication, Jean Bouchard, make it, and Mylène Bidot make it into a communication, and we send it to the state and we ask the state to respond. And if the state does not respond in 2 months, we name and shame. And you would be surprised how the state suddenly remember that they have to answer to us when they see their name on Twitter or on social media.
Merci beaucoup.
Dans la salle. N'hésitez pas, hein. Je te mets une question.
Oui, merci pour votre intervention. Moi, je me permettrais d'avoir une question. Au fur et à mesure de vos investigations, est-ce que vous avez vu vraiment des cas de violation de droits culturels en Europe? Ou est-ce que vous avez eu connaissance de cas de violation de droits culturels en Europe pour des raisons de protection de la biodiversité ou la mise en place de zones de protection de la biodiversité? Est-ce que vous avez eu des cas? Parce que dans votre rapport, en tout cas, vous citez un certain nombre de cas concernant des peuples autochtones. On en a quelques-uns, certes en Europe, mais ce que vous citez, c'est des peuples autochtones ou des populations locales ailleurs. Et donc la question qui était, c'est en Europe, qu'est-ce qu'il en est précisément?
So hundreds of violations every day. It's just that in order for me to cite anything, I have to have engaged with the state before I cite. And usually the communications have to do with states outside Europe. The first issue, hundreds, a lot of issues to be discussed. For example, Nordic countries and what they do for the projects, the oil projects, etc., and how they affect the local populations. But also, in many other countries. But I think that I am troubled by what you said, that I focus on indigenous peoples, because unfortunately, you're right. But unfortunately, this is what I did not want to do, because what states now say, the new thing is, yes, when it comes to conservation, we take measures for indigenous peoples. And what I have tried to say in the report, obviously not well enough, I should try to kind of say, to emphasize that even more, is that it's not just about indigenous peoples. It's about local populations. It's about everyone who lives. It's not about these exotic cases in Congo and in Laos. It is about, you and me living in the countryside in, I don't know, in the UK and in Greece and in France. So, I'm going to have to kind of focus more on this. The reality is that what I have been very worried is the Western states going and violating, in the name of conservation, the rights of people outside Europe. So development agencies, so the right hand of states, of developed states, going not to Europe, but to other parts of the world, and telling them that they're going to give them money in order to educate them. Does this remind you a little bit of colonialism? To educate them. And on the way of educating them, they take their timber, they, they kind of get trade contacts, and the project is always a huge success. It's just that, the local people didn't really understand what it was about, but it was a huge success. So I think that this is what I'm particularly interested in. So, but thank you. I have to focus more and to emphasize more, and maybe you can help me with that, because if you do send me communications like allegations of what's happening in Europe, then I can raise these issues, whereas otherwise I cannot on my own, and I cannot raise issues completely on my own, and I cannot raise issues only on the basis of media. So only on the basis of what I read on media. Before I go, because I know that you have a very exciting program, and of course, if you have any more questions and there's more time, absolutely. But before I go, I just want to make sure that I say something. I think that at the moment, anyway, my experience is that at the moment, I don't think that the conservation challenge, when it comes specifically to cultural rights, is mainly going to be played in courts. I think that the conservation challenge is going to play out in the interpretation that states have of the existing laws. So I think that in general, it will be a tall order. It will be difficult to ask states to introduce laws. If they do introduce laws on conservation, I would expect them also to say something about the preservation of cultural rights. But I think this is difficult. But what is easy is for NGOs to go to states and say, okay, that's great, but we have to have an impact assessment study that will also include the impact on the local populations, the farmers and the local populations. And so I think that at the moment, states have to understand that it's not only about protecting the environment, and they cannot protect the environment if they don't protect the local populations. And by protecting the local populations, it is not only financial remuneration, so only their livelihoods, and it is not only not kill them or not push them out. It is also about their identity and their traditional practices. And I think that this is the first step that we have to take and to win before we go further into legislation. But thank you so much for having me.
Merci.
Merci à vous.
Du coup, merci encore et je vous laisse peut-être avec ma collègue Marie qui avait peut-être quelques questions et juste quand même peut-être pour conclure dire que cette invitation qu'on vous a faite est issue aussi justement de notre participation à Eau Rivières à la consultation qu'a fait du coup la rapporteuse sur ces enjeux-là et voilà et donc voilà, c'est possible aussi, nous, de contribuer. Et à ce titre-là, on a fait un travail au sein d'Eau et Rivières. Et par exemple, on a beaucoup questionné la violation de nos droits culturels en Bretagne, en tous les cas, sur ce qu'on a nommé dans notre contribution la civilisation du bocage, en disant que voilà, c'était un marqueur de notre identité culturelle de territoire, hein, qui avait une incidence sur nos modèles agricoles, et qu'aujourd'hui, un autre modèle agricole venait finalement impacter cette culture qui est présente et encore, en tous les cas, qu'on défend et qui est la nôtre. Et donc voilà, aujourd'hui, clairement, en France, c'est considérer qu'être une civilisation du bocage, c'est une atteinte à nos droits culturels, on en est loin, comme le disait la rapporteuse. Voilà, c'est des considérations qui sont peut-être pas prises en compte nous-mêmes par nos États, alors qu'on a ratifié des textes et tout ça. Mais donc, je pense que c'est aussi important de contribuer à ces enquêtes pour que justement elles ne soient pas tournées que sur un droit des minorités à l'étranger, mais aussi de comprendre que en fait nous-mêmes on peut nous-mêmes on est atteints par ces cultures dominantes qu'on a assimilées, qui nous touchent peut-être un peu moins que d'autres, mais qui nous touchent quand même en réalité, quoi. Voilà. En tout cas, un grand merci de votre présence
Merci.
et merci, oui, et un grand merci à nos deux interprètes qui sont bénévoles, donc voilà, à leur investissement et dans cette rencontre. Voilà, merci
Thank you so
beaucoup.
much, interpreters and everyone.
Merci.